So we've been talking about court cases that have given our LGBTQIA plus siblings basic rights, right? Now, let's talk about the court cases that said, let's treat our LGBTQIA plus siblings like we treat anybody else fairly. Because apparently that was a foreign concept. I sound bitter because I am. Let's talk about the court case that said, hi, all 50 states, did you know you can't create blanket state amendments to your constitutions targeting soon-to-be protected classes? We thought you knew. Yeah. Let's talk about Romer v. Evans. Picture it. 1992, 2 years after I graduated from high school. The state, Colorado. The offending individuals, a bunch of homophobic, transphobic asswipes. They decide to make changes to the Colorado State Constitution. They call it Amendment 2. The amendment would have prevented any city, town, or county in the state from taking any legislative, executive, or judicial action to recognize homosexuals or bisexuals as a protected class. Now, high level, a protected class, is a group of people qualified for special protection by law or policy. Now, an example would be Black people. It's illegal to discriminate against Black people. Now, typically this group of people has a history of oppression in this country. Okay? Well, Colorado was like the LGBTQIA plus people will not become a protected class on their watch. And the amendment was approved by 53% of the population. Now, the amendment reads, neither the state of Colorado, through any of its branches or departments, nor any of the agencies, political subdivisions, municipalities, or school districts shall enact, adopt, or enforce any statutes, regulations, ordinance, or policies whereby homosexual, lesbian, or bisexual orientation, conduct, practices, or relationships shall constitute or otherwise be the basis of or entitle any person or class of persons to have or claim any minority status, quota, preferences, protected status, or claim of discrimination. This section of the Constitution shall be in all respects self-executing. Now, imagine being gay, living in Colorado, and this amendment was just approved. What are you going to do? Protest, obviously, yes. But wait, you've got PTO you need to burn. You worked for the Denver mayor, and you've got connections. So, why not sue to stop the amendment from taking effect? And that's exactly what Richard G. Evans did. Evans, along with other individuals and municipalities, brought a suit against the state, and a former Supreme Court justice was the lead attorney. A state trial court issued a permanent injunction against the amendment. Upon appeal, the Colorado Supreme Court said the amendment was, I'm going to put it kindly, a fucking hot mess. Yeah, and ruled that the amendment was subject to strict scrutiny under the Equal Protection Clause of the federal Constitution. I don't know how these states forget that the Constitution and the 14th Amendment exists. I'm so confused. How do they forget? Yeah. Now, here's my question for you. Did it pass strict scrutiny of the Equal Protection Clause of the Constitution. Did you say it did not? Because you'd be correct. It didn't. No. October 1995, the year after my daughter was born, the Supreme Court said that Amendment 2 of the Colorado State Constitution was unconstitutional. Surprise! They said that it violated the Equal Protection Clause of, say it with me now, the 14th Amendment. Yeah. Now, why was it unconstitutional? Because Amendment 2 singled out homosexual and bisexual persons, imposing on them a broad disability by denying them the right to seek and receive specific legal protection from discrimination. You can't do that. Justice Anthony Kennedy wrote, "It identifies persons by a single trait and then denies them protection from the board. The resulting disqualification of a class of persons from the right to seek specific protection from the law is unprecedented in our jurisprudence." And then he concludes with, "If the constitutional conception of equal protection of the laws mean anything, it must at the very least mean that a bare desire to harm a politically unpopular group cannot constitute a legitimate governmental interest. You cannot harm a politically unpopular group. You cannot harm the LGBTQIA plus group. You cannot harm women. You cannot harm blacks. You cannot harm Asians. You cannot harm indigenous groups. You cannot harm anybody you deem to be unpopular. You cannot harm anybody you deem to be unfit. You cannot harm transgender people." The bullshit that they've been passing these last few years is unconstitutional. And the fact that they're getting away with it disgusts me. But that is not related to what we are talking about. So I digress. Romer and Evans would set the stage for Lawrence and Texas. You remember that one, right? That's the case that said that LGBTQIA plus individuals could get freaky in the privacy of their own homes without fear of getting arrested. It would also set the stage for overturning the bans on gay marriage. And it would lead to Obergefell versus Hodges, the court case that gave us gay marriage. And Kennedy would be the author of the opinions in all of these cases.